for all of the entrepreneurs and founders, business owners, and executives out there. Here's the question. Do you read every contract that you sign? No, I mean, really, like, really, do you read every word of a contract that you sign? Not skim it, not forward it to somebody else to read it on your behalf. Like, do you read it? Do you read it and understand it? Not assume that your lawyer read it for you last time, so it's probably the same and you're going to just be fine. Every single word. I just got back from speaking at South by Southwest, and the talk I gave in Austin, this question was one of the things that really kind of made everybody take a breath. I was down there at South by Southwest talking about identity and AI and the future of how we do business, especially as entrepreneurs and executives and creators. That also includes professional athletes, anybody that's out there creating content, marketing your business, and putting yourself out there in a way that you're having to contract your name, your image, your likeness, or that of your business. The future of how we do business, especially as it relates to contracts, this is a huge deal. And it's not just some boring lawyer talk. It's not just a legal theory thing. Like, this is a real live cost somebody everything deal. So I asked the audience, who reads their contracts? And I bet you know the answer to that, right? I asked them, who's ever been surprised by something that was in a contract you didn't read? Again, I bet you know the answer to that. And that's where the gap is. That's where people lose money, they lose rights, they lose leverage, they lose maybe their whole business. Now, I know the objections you're saying. I hear you. You're saying, I have a lawyer for that. I pay the lawyer to read the contract. But does your lawyer know your business well enough to catch what doesn't belong in the contract? Does your lawyer understand your industry, your relationships, your risk tolerance? Or is the lawyer just marking up the language? The other objection I hear is, the contract's too long. I don't have time. I mean, contracts are long for a reason, and it's usually to benefit the person who drafted it. It's usually their reason, and it's not by accident. Another objection I hear is, well, it's standard. Everybody signs it. I literally was sitting in the bar at a hotel, drinking a glass of champagne and meeting some creators that were also at South by Southwest. And this one gal tells me about a big deal that she just signed with a big company. And I said, did you read your contract? What does your contract say about your AI rights? What does your contract say about your name, your image, your likeness, your voice, the future right that you have to your own voice? And she said, oh, I don't know. It was just a standard contract. Everybody signs it. I mean, if I didn't sign it, I wouldn't get the deal. There's no such thing as a standard contract. That's just something big companies tell you to get you to stop asking questions. The contract was drafted by somebody, for somebody, and if it wasn't drafted by you, for you, it wasn't for you. Another objection I hear is, well, I mean, I trust them. And I hope trust is enough. I hope your trust is well placed, but trust doesn't override what's in the writing. What's in a contract, what lawyers call the four corners of the document, that's what a judge sees, not the relationship, the document. Another objection, it's too complicated. I won't understand it anyway. Well, then you need to get somebody to translate it for you and explain it to you and make sure that you understand it. You don't need somebody who's just going to sign off on it. You need to understand it yourself. Because here's the real cost that you're paying for not reading your contracts. Rights that you didn't know you gave away. Clauses that auto-renew into things that you wanted out of. Non-competes that follow you after you leave. IP ownership that transfers to somebody else that should have been yours. Confidentiality provisions that silence you when you should be allowed to speak. Indemnification language that makes you responsible for things that shouldn't be your fault. I mean, these things aren't theory. This is a Friday. Let's talk about some specific contract provisions that show up all the time. These are things that can blow up in your face later, and I'll call them danger clauses. Usually they're buried in Section 9, Paragraph 3 in a font that is slightly smaller than the rest of the contract. How about an auto-renewal clause? The contract automatically renews for another full term unless you cancel in writing in a specific manner within a specific window. Miss that window by a day or a week, you're locked in for another year. I mean, I've seen businesses get locked into a 6-figure vendor deal that they wanted out of because they didn't calendar the deadline to get out of it because nobody read the contract. And then when the vendor won't let them out of it because they missed the deadline, they feel that the vendor is being predatory, but the vendor's not being predatory. The vendor's relying on the contract that you should have read, calendared, and been prepared for. The IP assignment clause. I mean, this one is particularly dangerous right now. People are getting bit in the rear by the IP clauses right and left. If you're a founder, if you're an executive, if you're a CEO, if you're a creator, if you're a professional athlete or want to be one, this is something you need to be watching out for right now. If you're signing an agreement, could be just a simple sponsorship deal, could be a service agreement, a content deal. Maybe there's some language in there that assigns ownership of everything you create during that contract term to the other party. Maybe it's some sort of language that says that you are giving up all media rights to your creation that you agreed to create, or derivative rights to the media that you agreed to create. Do you know what all that means? Like, those are ways of saying that the creation that you agreed to create, the 3 photographs for the cupcake shop, that any derivative of those, so in other words, they could take your 3 photographs and put them in AI. The little short reel that you agreed to create for Instagram of the cupcake shop, they could take that and put it in AI and then create derivative reels based on your AI without paying you forever and ever in perpetuity, if perpetuity's in there. So it's not just what they paid you to make. A clause like that would give them the right to take what you created, that one little reel, those 3 little photos, and use it over and over and over again to create a derivative work, and you signed away everything. I've seen people sign away the right to content, the right to their name, the right to creative works, that they created completely independently of that contract, all because the assignment language was too broad and nobody caught it. You know, it's not that people are careless, it's that they're busy. They're trusting. They assume that if there was a problem, somebody would tell them. But nobody tells you. I mean, nobody's coming to save us. That's not how it works. A contract is a contract for a reason. You have to read it. So what do you do if you're a high-performing executive, if you're a founder, an entrepreneur, a professional athlete, a creative, an entertainer? You're moving fast, you're making big decisions. You don't have time to slow down, but you can't afford to get these things wrong. That's why I built Concierge Advisory. It's a strategic advisory, concierge level service for people whose problems are too big, too complex, too important, or too personal to be handled like a commodity. This is not a law firm. This is not generic business coaching. This is what happens when a trial lawyer, a litigator with decades of experience watching what happens when things go wrong that cost people everything, things that people wish they had known. When that person builds a service to solve your problem before it becomes a problem, to sit beside you and help you strategically solve the problem before it becomes a problem. I work with executives navigating high-stakes decisions, with founders who are scaling but can't afford the blind spots, with athletes and public figures managing their reputation, their name, image, likeness, their brand, their legacy, with business owners whose next move might be the one that changes everything. You get strategy, you get clarity, you get someone in your corner who will tell you the truth, not just what you want to hear. Concierge level service, because that's what the stakes require. If you're watching this and something I said landed, if you feel like we need a longer conversation, if you have thought about a contract you signed without reading it, or a deal you did on trust, a moment where you wish someone had been in the room with you and understood the full picture, not just part of the picture, let's talk. Drop me a comment, send me a DM, or go to conciergeadvisory.com. I'll put it in the comments.